Imagine spending months gathering documents for your marriage-based green card, only to get a letter that simply says denied. No warning, no request for more evidence, nothing. This is the reality under a brand new immigration policy that could affect thousands of families starting right now. Immigration officers now have the authority to deny your case outright without asking for additional evidence, a sharp departure from decades of practice. This means even a small oversight in your paperwork can lead straight to denial and, in many cases, deportation proceedings. You'll learn exactly which mistakes can trigger an instant denial, real-life scenarios you must avoid, and steps you can take to protect your case. This is not the time to guess or cut corners. Welcome back to Visa Intel USA. Why this policy is different. For over 20 years, the standard process was that if your application was missing a document or if something was unclear, USCIS would send a request for evidence, RFE, or a notice of intent to deny, NOID. You had a chance to respond, fix the mistake, and keep your case alive. Under this new policy, that safety net is gone for many applicants. Officers now have the discretion to reject your application immediately, no second chances. This is meant to streamline processing, but in practice, it puts a lot more pressure on you to submit a perfect application from day one. Scenario 1. Financial support problems. One of the fastest ways to get denied is to submit incomplete or incorrect Form I-864, Affidavit of Support. This is the form that proves your U.S. sponsor can financially support you. Before, missing a tax return or leaving a section blank would simply lead to an RFE. Now, those same mistakes can kill your application on the spot. Self-employed sponsors often run into problems because their reported income after deductions appears too low. If that's you, you might need to count assets or get a joint sponsor, and this must be done before you file, not later. Scenario 2. Weak relationship evidence. If you're applying through marriage, your proof must be rock solid. That means more than just a marriage certificate. Include joint bank account statements, lease agreements, bills in both names, travel records together, and plenty of photos across different times and places. Immigration officers are trained to spot paper marriages, and now, instead of asking you for more evidence, they may simply deny you if they feel your proof is thin. Scenario 3. Missing required forms or documents. It sounds obvious, but it happens constantly. Applicants forget to include a required form or signature. Maybe you filed Form I-130 and I-485, but forgot the I-864. Before, USCIS would send a polite letter asking for it. Now, denied. This is why even if you can't hire an attorney for the whole process, it's worth paying for a one-time legal review before submitting your application. That investment can save you from losing thousands later. Scenario 4. Inconsistent information. Inconsistencies across forms are another red flag. If your address on Form I-130 doesn't match your I-485, or your dates of entry don't match your travel history, USCIS might view it as a credibility problem. Previously, they might have asked you to clarify. Under the new rules, they may simply reject the entire package. Scenario 5. Prior immigration violations. If you've been denied before, overstayed a visa, or had removal proceedings in the past, you can't just start fresh without addressing your history. These issues must be clearly explained and supported with the right legal arguments. Otherwise, officers can deny without even opening the door for an explanation. Here's the hard truth. This policy isn't just about efficiency, it's about reducing approval numbers without officially changing the law. By shifting the burden entirely onto applicants, USCIS can quietly increase denials while pointing to incomplete applications as the reason. That means your case has to be bulletproof from the first page to the last. Think of your submission as a courtroom presentation. Every claim must be supported, every gap explained, and every form consistent. If there's even a single weak link, the officer now has permission to end your case before you ever get a chance to fix it. How to protect yourself. Prepare a complete package. Double-check every required form, signature, and attachment. Over-document your relationship. More evidence is better than just enough. Verify consistency. Compare every date, address, and name across forms. Address past issues. Be transparent about prior immigration problems and include supporting documents. Get a professional review. Even if you file yourself, have a qualified immigration attorney review everything first. Final thoughts. This new policy is a game changer for marriage-based green card applicants. There's no room for error, no fix-it-later stage for many cases. The safest approach is to treat your initial submission as your only shot, because for many it will be. If you're in the process now or planning to file soon, take the time to prepare the strongest, most complete application possible. Borrow the funds if you need professional help. It's far cheaper than fighting a denial and possible removal in court later. If you found this breakdown helpful, subscribe to Visa Intel USA for the most up-to-date immigration news and strategies. Like this video so more people can see it, and share it with someone who needs to know about these changes before they file.